We're not actually here to talk about the citizenship question. Because what happened next is truly the most remarkable part of this. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. We have had an interesting time here in America with the upcoming 2020 U.S. Census. The census is the official count of all of the citizens. Or actually, isn't that's a Freudian slip for you right there. It is not a count of all the citizens. The census is a count of all the people in the country, and the Trump administration wants to add a citizenship question, which has not appeared on the census since 1950, I believe. And so what we had, this is not the story, but what we had here is a decision where Judge Jesse Furman has issued an opinion and decision that permanently enjoins the Secretary of Commerce and the Director of Census from adding the citizenship question. And then that got appealed to the U.S. Supreme Court, which is where we're going to start today. So this is in the Supreme Court of the United States. In order to apportion congressional representatives among the states, the Constitution requires an enumeration of the population every 10 years to be made in such manner as Congress shall by law direct. In the Census Act, Congress delegated to the Secretary of Commerce the task of conducting the decennial census every 10 years in such form and content as he may determine. The Secretary is aided by the Census Bureau, a statistical agency in the Department of Commerce. The population count is also used to allocate federal funds to the states and to draw electoral districts. In March 2018, Secretary of Commerce Wilbur Ross announced in a memo that he had decided to reinstate a citizenship question on the 2020 Census questionnaire at the request of the Department of Justice, which sought census block level citizenship data to use in enforcing the Voting Rights Act. The Supreme Court held, I'm skipping some parts of it, that the enumeration clause, the census clause, permits Congress, and by extension the Secretary, to inquire about citizenship on the census questionnaire. But the Secretary's decision is reviewable under the Administrative Procedure Act, so something you may not have caught up there is that Congress was the one assigned the power to conduct the census, but then it's the executive branch that seems to be directing it. Well, that's because of the Administrative Procedure Act. The APA, or Administrative Procedure Act, allows Congress to delegate its authority to administrative agencies. Administrative agencies are run by the executive branch, but the agencies are given no discretion or very little discretion to conduct their operations. They have been given procedural limits on how they conduct their jobs and how they conduct their purposes, and they have to follow those limits. So if they go outside of those limits, the APA instructs reviewing courts to set aside agency action that is arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law, but makes review unavailable to the extent that an agency action is committed to agency discretion. Discretion being a fancy word for saying that this is what they're allowed to do, what they've been given the task to do, and they're allowed to do this. If the agency is the agency of keeping town square clean, and they're given the authority and the discretion to do what must be done to clean the center square of the town, well, they're allowed to clean the center square of the town and purchase items to clean the center square of the town and hire employees and send them with their equipment to clean the center square of the town. But then when they go start an ice cream store, now they're outside of their, or ultra vires, which is the Latin phrase for that, they're outside of their authority. And so that would be reviewable under the Administrative Procedure Act. In order to permit meaningful judicial review, an agency must disclose the basis of its action. A court is ordinarily limited to evaluating the agency's contemporaneous explanation in light of the existing administrative record. Also a lot in there. In order to permit meaningful judicial review, not just review on its face, not just a meaningless, oh, well, you came into court and we decided against you. No. They have to do things and take steps that that mean things to the parties. So that means taking testimony from both sides and hearing their arguments and hearing from their witnesses and building court record and all that. So the judicial review has to be meaningful, and the court evaluates the agency, in this case the Census Bureau and its directors, contemporaneous explanation. These are key words: contemporaneous, simultaneous explanation. The explanation given for the action at the time that it was taken. There's a reason why I'm stressing this so much. But it may inquire into the mental processes of administrative decision makers upon a strong showing of bad faith or improper behavior. While the district court prematurely invoked that exception in ordering extra record discovery here, it was ultimately justified in light of the expanded administrative record. Accordingly, the district court's ruling on pretext will be reviewed in light of all of the evidence in the record, including the extra record discovery. It is hardly improper for an agency head to come into office with policy preferences and ideas, discuss them with affected parties, sound out other agencies for support, and work with staff attorneys to substantiate the legal basis for a preferred policy. So the court is saying, the Supreme Court is saying, that there's nothing wrong with the director and the Census Bureau and all that having a political agenda. What they need to do is state the more or less rational basis or the proper basis for the change that they're making. And the court goes on, yet viewing the evidence as a whole, this court shares the district court's conviction that the decision to reinstate a citizenship question cannot adequately be explained in terms of DOJ's request for improved citizenship data to better enforce the Voting Rights Act. Several points taken together reveal a significant mismatch between the Secretary's decision and the rationale he provided. The record shows that he began taking steps to reinstate the citizenship question a week into his tenure, but gives no hint that he was considering Voting Rights Act enforcement. So if the stated contemporaneous reason is to enforce the Voting Rights Act, there should be evidence that he was talking about the Voting Rights Act in relation to the citizenship question and all that when he proposed the citizenship question. There was not. His director of policy attempted to elicit requests for citizenship data from the Department of Homeland Security and DOJ Office of Immigration Review before turning to the Voting Rights Act rationale and DOJ's Civil Rights Division. Altogether, the evidence tells a story that does not match the Secretary's explanation for his decision. Unlike a typical case in which an agency may have both stated and unstated reasons for a decision, here the Voting Rights Act enforcement rationale was the sole stated reason and seems to have been contrived. The reasoned explanation requirement of administrative law is meant to ensure that agencies offer genuine justifications for important decisions, reasons that can be scrutinized by courts and the interested public. The explanation provided here was more of a distraction. In these unusual circumstances, the district court was warranted in remanding to the agency. So then, the Supreme Court has remanded or affirmed the remand back to the district court, and the district court holds various hearings. And of course, the rule now is that you can't put the citizenship question on the census. And then Donald Trump tweets, "The news reports about the Department of Commerce dropping its quest to put the citizenship question on the census is incorrect, or to state it differently, fake. We are absolutely moving forward as we must because of the importance of the answer to this question." Well, that sort of directly contradicts the judge, right? That's what the judge ordered. And then the judge holds a hearing on that. "Good afternoon. Who do I have for the plaintiffs?" Hewlett for the plaintiffs, and Duraswamy. And for the government, it's Ben Duke, Josh Gardner, Jody Hunt, and I think that's the three there. Judge says, "So I guess the reason I wanted to have this call, obviously, we had our call, I guess it was yesterday. It feels like a while ago, but I think it was yesterday. And this morning, I saw a tweet that got my attention. I don't know how many federal judges have Twitter accounts, but I happen to be one of them, and I follow the president. So I saw a tweet that directly contradicted the position that Mr. Gardner, the government's attorney, shared with me yesterday. I'll say in that regard that I had felt somewhat bad about not just immediately accepting Mr. Gardner's representation and sort of taking some measures to try to pin it down. I think I even indicated yesterday, and I'll indicate again today, that Mr. Gardner and every government attorney who has appeared in this case has been nothing but professional and candid with the court. And so my attempts to pin him down yesterday were not sort of any reflection on him and what I think of his candor. But then the tweet that I saw, which I suspect we all know the tweet I'm referring to, then caused me to think I hadn't gone far enough in terms of pinning the government down on where things stand. So now we have a court reporter here. I'm going to ask, frankly, the same question I asked yesterday to Mr. Gardner. Is the government going to continue efforts to place a citizenship question on the 2020 census? Mr. Gardner answers, Your Honor, I want to back up just a step and say that I've been with the Department of Justice for 16 years through multiple administrations, and I've always endeavored to be as candid as possible with the court. What I told the court yesterday was absolutely my best understanding of the state of affairs and, apparently, also the Commerce Department's state of affairs, because you probably saw Secretary Ross issued a statement very similar to what I told the court. The tweet this morning was the first I've heard of the president's position on this issue, just like the plaintiffs and Your Honor. I do not have a deeper understanding of what that means at this juncture other than what the president has tweeted. But obviously, as you can imagine, I am doing my absolute best to figure out what's going on. I can tell you, I have confirmed that the Census Bureau is continuing with the process of printing the questionnaire without a citizenship question, and that process has not stopped. And then they go on to plaintiff's counsel, underscores the need for a stipulated order, etc., etc., etc. I don't know how much more is in here because we're not actually here to talk about the citizenship question. Because what happened next is truly the most remarkable part of this. All of the attorneys tried to withdraw. So every single one of the Department of Justice attorneys who are representing the United States in this lawsuit filed this. Please take note that going forward, defendants, the United States Department of Commerce, Wilbur Ross, Bureau of Census, Director of Census Bureau, will now be represented in this matter by different counsel from the Department of Justice. Okay, just keep in the back of your mind where they're going to say which counsel, like who the new people are. Because the Civil Division has been involved in litigating this case to date, which is like 2 years now, March 2018, so a little over a year, integer 2 years, but float 1.34 years. And new attorneys from the Civil Division will be entering their appearances. Defendants do not expect that withdrawal of current counsel will cause any disruption in this matter. Accordingly, pursuant to Local Rule 1.4, defendants respectfully request that the court order the withdrawal of the following counsel and no longer send them docketing notifications via the electronic case filing system. Kate Bailey, James Burnham, Garrett Coyle, Stephen Ehrlich, Carol Federighi, Joshua Gardner, John Griffiths, Martin Tomlinson, and Carlotta Wells. Defendants also ask that the court's order approve the withdrawal of Brett Shumati and Alice LaCour. Mr. Shumati no longer works at the Department of Justice, and Ms. LaCour no longer works with the department's Civil Division. None of the withdrawing counsel are retaining or charging a lien, and this is signed by them. Where did they say who's replacing them? You know they're supposed to, right? They're supposed to state, well, I'll let the judge say it better than me. Because Judge Jesse Furman, the United States District Judge in this case, denied their withdrawal. On July 8th, 2019, defendants filed notice of motion to withdraw as counsel, advising the court that going forward, defendants will be represented in this matter by different counsel and seeking leave for 11 attorneys, many of whom have represented defendants since this case began in early 2018, to withdraw. Defendants assert, without elaboration, that they do not expect the withdrawal of current counsel will cause any disruption in this matter. The same day, plaintiffs filed a response to defendants' notice of motion. Rule 1.4 of the Southern and Eastern District of New York local rules governs the withdrawal of counsel. It provides in relevant part, an attorney who has appeared as attorney of record for a party may be relieved or displaced only by order of the court, and may not withdraw from a case without leave of the court granted by such order. Such an order may be granted only upon a showing by affidavit or otherwise of satisfactory reasons for withdrawal or displacement, and the posture of the case, including its position, if any, on the calendar, and whether or not the attorney is asserting a retaining or charging lien. You might remember from the Alex Mauer case, we had to go to court, and the one time that Alex showed up with an attorney, it didn't work out, and that attorney had to file way more comprehensive notice of withdrawal or motion for withdrawal than what was filed here. What was filed here was this one-page notice of nothing, just literally, we want to withdraw. And that, as you just saw, is meaningless within that paragraph. It needs to be supported, and it needs to state the posture of the case, and it needs to give good reasons, and maybe even tell you who the new attorneys are going to be. And they didn't do any of that. Thus, when considering whether to grant a motion to withdraw under Rule 1.4, a court must analyze the reasons for withdrawal and the impact of the withdrawal on the timing of the proceeding. With respect to the latter factor, a court must consider the posture of the case and whether the prosecution of the suit is likely to be disrupted by the withdrawal of counsel. Measured against those standards, defendant's motion is patently deficient, which patently means on its face or on its outside, except for the motions for Brett Schumati and Alice LaCour, who have simply left the Department of Justice and Civil Division. Defendants provide no reasons, let alone satisfactory reasons, for the substitution of counsel. And as to the second factor, defendants' mere expectation that withdrawal of current counsel will not cause any disruption is not good enough. Particularly given the circumstances of this case, defendants' opposition to plaintiff's most recent motion is due in just 3 days. Anybody notice they didn't mention that in the posture of the case section that wasn't in the notice to withdraw? So this was basically like, this was the Wayne Gretzky of withdrawal motions. This is the answer's no if you don't ask. We might not have any good reasons for asking. We're just still going to ask because there's a chance you might grant it, Judge, and let us off the hook. Is it possible that maybe these lawyers don't want to represent this administration on this particular question? I'm looking at the wrong camera. I'm staring at this camera, and this camera is the one on. We're gonna get.
You want to ask your question again?
No.
Screw the editor.
I love you, Leonard. You're the best.
I think what's interesting here is something that's really important for lawyers that maybe some lay people wouldn't know, is that every court has their own rules. And so although they're dealing with a federal issue in this case, and these are federal lawyers, the local court that they're dealing with has their own rules, and then the local judge also has, his own rules, and you have to know all the rules. So there's like four or five sets that
the judges are usually nice about the rules, and if you've gotten the rules wrong, they'll try and help. They'll try and give you a chance to correct it. They don't usually bring the hammer down. You saw that in the Alex Mauer case. The Alex Mauer brief was or answer was due 2 months and 2 months later or whatever, and she turned it in 2 months and 3 days later, and the judge wouldn't let me do anything about that. Defendant's opposition to plaintiff's anticipated motion for sanctions is due later this month, and in the event that defendants seek to add the citizenship question to the 2020 census questionnaire based upon a new rationale, time would plainly be of the essence in any further litigation relating to that decision. See the previous docket entry acknowledging the need for expedited litigation in that event. As the court observed many months ago, this case has been litigated on the premise, based in no small part on defendants' own insistence, that the speedy resolution of plaintiffs' claims is a matter of great private and public importance. If anything, That urgency and the need for efficient judicial proceedings has only grown since then. Accordingly, defendants' motion is denied without prejudice to renewal, which means they can correct their mistake and refile the motion to withdraw. They just have to take care of those deficiencies, show the good cause, maybe name the other attorneys that are going to be substituting as counsel, and explaining why it's not going to impact the court's calendar. And they do grant the motion to the 2 attorneys who had left the departments. Any new motions to withdraw shall be supported by a signed and sworn affidavit from each counsel seeking to withdraw, 1, stating satisfactory reasons for withdrawing at this stage of litigation, and 2, in light of plaintiff's forthcoming motion for sanctions, confirming that he or she submits to the jurisdiction of this court with respect to that motion and any future motions regarding sanctions, and that he or she will be available in the event that the court requires his or her attendance at any such future hearings. In the event any new motion is filed, new counsel for defendants shall also file an affidavit providing unequivocal assurances that the substitution of counsel will not delay further litigation of this case or any future related case. The clerk of court is directed to docket this in the related cases, to terminate the 2 approved attorneys as counsel, and to terminate the other matters. Says Jesse Furman, United States District Judge for the Southern District of New York. So that's really interesting. I believe we had a follow-up then, a very, very maybe not so approving tweet from President Trump. So now the Obama-appointed judge on the Census case won't let the Justice Department use the lawyers that it wants to use. Could this be a first? And my answer is no. This is not a first. The department's lawyers just simply need to follow the rules of law, something that the president's administration seems to have a lot of trouble doing, which is really funny because I would normally consider a president or political leader to be much more highly educated and intelligent than someone like myself even. And it is quite obvious that I do a better job of following the rules. Even the rules I disagree with, I do a better job disagreeing with them than the President of the United States. So think about that for standards for you. That is our show. Thank you for joining me today, everyone. I am Leonard French, your favorite copyright attorney. Thank you to our patreon.com/ljfrench and sponsors.org/law supporters who support us financially and make these stories possible. Thank you to Joshua Davis, who is supporting us in July at the $500 level. We're going to make a video for Joshua about the TandaPay service that he has developed. It is a social insurance program that is based on the blockchain, and we're going to see what's super interesting about this. Thank you very much to our $50 plus supporters, Jonathan Steele, Gavin Barnard, Kyle Mudrak, Eevi, I almost said Andy. Yeah. Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky. Thank you very much for your support at the $50 level. And thank you to the $5 plus supporters, including Joe Tyson, who I forgot about, so I'm making it up to him, who are scrolling on the LED panel behind me and will be in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. This has been Kaylee with us here in the studio. Brandon and Tactical and Kurt Mueller have been in the virtual studio. Thank you very much for joining us there. I'll leave some room here for the editor to put some dog video, but here is also a dog for you. Hup. Good boy. Good boy, that's my dog. This is Nico. Nico has also been in the studio today. Up. And I hear an Ilsa. I hear an Ilsa. Do we have an Ilsa coming over? But you can't see her on the camera. That's great. So, thank you very much for joining me. It's been a wonderful Sunday. We'll see you on Wednesday. And that's it. Love you all. Bye.